We've got most people joined here now anyway. So yeah, good afternoon everyone, and welcome to our insolvency webinar today. We're delighted you were able to join us. We have three highly esteemed speakers today. We've got Ronan Duffy, Keith Farry, and Gary Scott. Each of whom brings a wealth of experience and knowledge in insolvency law and financial restructuring. So without further ado, I'll pass you over to Ronan, who's going to kick things off for us here today.
Right, bear with me 1 second. There we go. Can you all see that?
Yeah.
Is that okay? Right.
Yeah.
Thanks for that, Damien. Kind words. When you said esteemed individuals, I was wondering who was joining us, but we just have to settle for us three. We have a bit of a whistle-stop tour for the hour that we have. I'm going to cover off a little bit about personal insolvency. Then Gary's going to come in and he's going to talk a little bit about the corporate side, primarily around SCARP. And then we have, we're very pleased to have Keith join us. Keith, obviously, as many of you know, is extremely experienced in the insolvency arena. I'm not saying is used exclusively by us, Keith, but nearly. I think probably exclusively by everybody in the personal insolvency arena on the PIP side anyway. What I look to do is I'm going to take a couple of I've got some slides to run through here, and if you ask any questions, you can pop them in the chat box, and we'll try and deal with them as we go. Okay. What I propose to look at is just really a bit of a recap of where we've got to in personal insolvency here in Ireland. I'm going to look a little bit about the stats. I've got some case studies to look at, and then just a bit of pointers around practical case management strategies. Just worthwhile though, trying to pause and take a moment to remember how we got here. We have had bankruptcy in Ireland since 1571. But for most of that time, that was the only statutory personal insolvency solution. And it was for many years very, very draconian. And it was, it wasn't really a widely used statutory solution. I think you only have to go back to about 2006 that if you went into bankruptcy in Ireland, you were literally 1 in a million. That's how little used that it was. So when we had the crisis back in 2007, 2008, they obviously looked at, the government looked at what they needed to do to try and change the insolvency legislation. They were under pressure, obviously, to do that. And they brought in the Personal Insolvency Act in 2012. So it's only 12 years that since we've had a sort of, if you like, a proper fit for purpose is maybe a stretch, a fit for purpose regime. And it affords 4 statutory solutions. So bankruptcy was significantly reformed. The duration that somebody would be in bankruptcy was reduced dramatically to bring it in line with other jurisdictions, and then it introduced sort of 3 new statutory solutions. Quite novelly, it introduced one that dealt with not just your unsecured liabilities, but also dealt with the secured liabilities. That's quite unique in the world of insolvency, and that was the personal insolvency arrangement. It introduced another mechanism, which is effectively supposedly an out-of-court mechanism for dealing with the unsecured liabilities, and that's a debt settlement arrangement. That has many sort of other jurisdictions have many similar type arrangements. And the debt relief notice again has has similarities to arrangements in other countries where it's kind of low income, low assets. It's at the it's supposedly sort of bankruptcy light, and the debt relief notice was that quite akin to a DRO in the UK. Debt settlement arrangement quite similar to an IVA arrangement in the UK as well. Okay, but at the moment, so we've had 12 years now. The first case that under the legislation was actually one of mine, and I remember at the time being sort of very focused on trying to get the mechanics right, trying to get the figures, trying to get the and it was sort of putting in tables, and it was my Excel and my Word, and trying to get things that get it all in place. And then we actually had the creditor. The meeting of creditors to vote on the debtor's proposal, which was a debt settlement arrangement, and at that I was quite, I remember I actually had a physical meeting. Most meetings happen virtually, but this one was a physical meeting where we actually provided buns. I seem to recall some of the banks turned up, ate the buns, and still rejected, which is hardly a surprise, perhaps. But there was enough of creditors were prepared to support it that it would have it passed the 65% threshold. Interestingly, I recall that it would have been, had it been an IVA in the UK, would have been rejected, but because the lower threshold of the 65 as opposed to the 75, it was accepted. But I was very, very focused on how this actually all came to clicked together, how it all came together. And I really, it's not that I forgot about the debtor, but that was almost like, well, we'll just get this sorted. After we had that arrangement put in place and accepted by creditors, not long after that, the debtor wrote to us, and it kind of it was very, very humbling, but it kind of really hammered it home to me that he felt that Cambridge Duffy had actually saved his life. He had there had been a history of incidents of self-harm and obviously vulnerability, and the fact that he felt that there was a way out, there was a pathway where before that there was nothing, that there was a path to recovering to solvency, and he was incredibly grateful. But I was embarrassed that I was kind of focused on the mechanics and the nuts and bolts of it rather than the actually remembering at the end of it that there was a person. Fast forward the 12 years, there's that landscape of personal insolvency has evolved. I don't provide cream buns for any creditors now. And as I say, most of these meetings happen virtually. That's not to say that there's not been massive challenges. I think a lot of the attitudes for a lot of the banks, particularly around the mortgage restructures, was a kind of a delay and pray, where they would sort of kick the can down the road and hope that property prices come back. And obviously, we have seen that property prices have come back to 2008 levels. Therefore, perhaps that strategy was the right for them. Don't necessarily think it was the right thing for the debtor, but perhaps for the creditors that was the right approach. But we're all well aware of the housing crisis in Ireland at the minute, and the consequences of somebody not being able to deal with whatever their debt problem with regards to their mortgage is quite dramatic, because if they're dropping off into the property gets repossessed and they're not able to restructure, property gets repossessed, and then they're actually looking at going into a rental market, which we all can sort of see how expensive that is. So I think that what I'm trying to say is that the past 12 years has been one of evolution and bedding in of the act. But it's sometimes worthwhile sort of remembering how long it took to get there and how long how far we've come in such a short period. I think Ireland, the insolvency regime and sort of, for want of a better word, insolvency heritage has built up in just over a decade what took sort of the UK perhaps 4 decades. So I do think it had been sort of greatly accelerated. Just touching at the mortgage arrears stats, I'm not going to dwell on them massively, but just to keep in mind, mortgages, there's around 700,000 mortgages in Ireland with a value of about 102 billion. Of that 700,000 mortgages, 46,000 are still in arrears. Now the hardcore arrears, those that are in arrears longer than 90 days, which is sort of the traditional measure, it's around 28,000. So that's still 4%, which is quite significant. If you look at the recent statistical releases around the mortgages, you can see though that the amount of those bank mortgages, if you like, that are in hardcore arrears has been declining. It looks like the banks have done such a good job. And then you look at the non-banks and the funds, and you can see that rising, quarter after quarter after quarter. And clearly what's happened is obviously that the banks have just offloaded these to the funds. But dealing with that sort of what I've termed the sort of hardcore or the longer term of the arrears amounts is incredibly tricky. One thing I would say is, quite a lot of times, these are the arrears get capitalized, or that they're just warehoused in some way. But if a debtor's getting something warehoused, quite often there's no, and this solution, sorry, is being put in place by the arrears support unit or of the bank or the fund. Quite often there's no real way of addressing that is put in place, and it's kind of like it's that delay and pray, again by a different mechanism. What I would say is, I'll come back to, is that the funds are actually, they get called vulture funds. They get, and actually I think on the next slide, which is called that, but they quite often they're quite pragmatic, and they're quite prepared to they bought these mortgages at probably in a portfolio at a fairly reduced rate, and they're prepared to do something to make it to make it work and make it pay for them. And quite often when it goes to a PIP, there's that toolbox that those creditors have opens up more, because what the solutions that they have within the arrears support unit are not necessarily everything that might be brought into play. But of the case studies, of some of the recent case studies, many of you might be might have seen this one. I think it generated, this is one of again, it was one of mine. It was one of Keith's as well. And it's one of those ones that sometimes there's incredibly difficult cases, and I think it gives heart to people to realize that even in difficult cases, you can actually find a solution. In this one, the debtor in question, we're going to call her Helen. She was a personal assistant, and she was separated. A lot of the financial struggles for her stemmed from her estranged husband and his actions, because he had remortgaged the home without her knowledge. And it's it was very, very difficult. And I'm not saying that all debtors out there are going to get a case where we can sort of use a PIA to reduce the rate fixed for 17 years to 0.5%. But as I say, it was a tricky one, and it offers hope potentially to those sort of what we term age challenged debtors. Quite often the cohort that we see now are around sort of older mortgage holders, and it's kind of that's sort of can be difficult to find a solution for them. The lowest rate previously imposed under a PIA was 2.5%. So the fact that it was 0.5% gives you an idea just how difficult the actual case was. When I said about the aged debtors, most lenders are prepared to look at some sort of solution extending the mortgage out to, or sorry, the mortgage out to 80. But we have, so that's obviously typically well beyond retirement. But we have found had some success with cases to 90 and beyond. A kind of lifetime tenure restructure. An example of that might be where the debtors pay a live mortgage until retirement and then pay interest only in their retirement years, dealing with the reduced retirement income. Again, some of the funds, like start mortgages, were actually were particularly good with the sort of the lifetime tenure restructures. So although it can be fraught with difficulties, everything is still possible. And but I appreciate that was still a Section 115A challenge, which obviously Keith ran with for us. The Section 115A is just worth bearing in mind as well. There's only really one other jurisdiction and that's the Netherlands, that has that kind of the creditors say no. We put it in front of we'll put it in front of the court, and then the court has the power to impose. The Netherlands and ourselves are quite unique around that, Another case study that I thought was interesting was again, they were sort of in the age challenged. John and Helen, 69, 67, both retired. Didn't have any unsecured debts, but they had income from pensions, and they also had family members who were prepared to help out. So what we did is we looked to capitalize the arrears, reduce the interest rate, and extend out. So that's a nice one where it was a mix of various aspects. And in that one, we reduced the restructured mortgage payment was 1,050, and that was affordable for them. That one I seem to recall the lender was Mars. So again, it's one of those ones. As a PIP, you have more options, I think, is probably what I'm looking at, and quite often the funds and the banks are quite happy to see that they that the PIP's in place, because they have access to those alternate solutions. And the other thing is actually just what it said, sorry, about on the last page, is about when I was saying about the Netherlands and ourselves, but the Section 115As. Quite often when you go for go down the Section 115A route, it's kind of an optional last resort, I guess. It's not ideal. You don't want to do that. The creditors don't like it. We don't like it. Debtors, it doesn't provide any certainty. So quite often deals are done. Some sort of compromise can be reached with the creditors, even at that stage, and that is actually a pretty good I think we should, in this country we beat ourselves up too much about things, but this is something that I think is actually better than a lot of jurisdictions in that respect. Just thought it'd be useful to touch on a DSA. Now again, that relates to the unsecured liabilities. Seamus, he was a plasterer, 44, father of 3. The PPR was unencumbered in that one, but it had a very significant MICA issue, which is going to have to be addressed going forward. But Seamus didn't have his head in the right place in terms of trying to deal with his unsecured liabilities and then go forward with dealing with the the mica issue on the house. And he did. He was very reluctant to initially to make contact with ourselves, but he then sort of, I guess that, I always kind of liken it to the most difficult call they make is that first call. He did then come on board, and we sort of put together a proposal which would deal with 300,000 residual liabilities which were had arisen from buy-to-lets which had been voluntarily surrendered. And so he put forward a full and final proposal. So it was a one-off DSA based on 15,000 euro being introduced. And again, that had been sort of sitting in the background, on the creditor's books for a long time. But it was following him around every day. It was like a black cloud, and it was there all the time. And that the DSA is in place to get him out of that and get him back to solvency, and he needs to focus then on his family and addressing the mic issue. That's fine, but the creditor was happy to accept that. We're seeing quite a lot of those types of DSAs. I think I'm talking too much. I'm sure Keith and Gary are chomping at the bit, but I've got a couple of slides to rattle through. So I think for people on the call here, we have a mix of solicitors, of accountants, and debt advisors, and a lot of guys from MABs who do such good work. And I think it's probably a couple of things I just kind of wanted to say is that, I guess, stemming on from what we were talking about Seamus, is that trying to do that early intervention, trying to do that, look, that they actually don't take an ostrich-like approach, that they do face up and try and address the problem. We all know the studies are there. Debt has significant impact on not only on mental health, but it also has an aggravating fact on existing health conditions. So in all those, as advisors, you have a role to play in trying to encourage them, trying to sort of get them to prepare, pulling together information, pulling together, if they're self-employed, pulling together, cash flow analysis, those types of stuff, pulling together their financial position. And obviously the solicitors here, you need to advise them of their rights and obligations in insolvency, and sort of direct them to get appropriate professional advice from a PIP. The early engagement, can't stress enough on that. It is just the as soon as there's a problem, try and address it. We found for the most part, notwithstanding that there are Section 115As and some creditors have reputations for being sort of, I was going to say hard asses, but I probably should say difficult. But for the most part, creditors are prepared to work with debtors. Sometimes they actually, they still surprise us in terms of how far they're prepared to go. But I think that the creditors that we have, yes, they're aware of the Section 115As on the PAA front, but they were aware of that sort of sword of Damocles hanging above their head. However, for the most part, they actually want to try and work with people, and we do find that. I would just say, just to wrap up, that basically, every financial problem has a financial solution, and every debt problem has a solution. Quite often we have seen that debtors have received bad advice. They have received barroom and insolvency practitioners giving them advice to stop paying and you'll get a deal and that kind of stuff. And that kind of can make our jobs a bit more difficult if they've been told to stop paying and then they get out of the habit of paying for something. Then it kind of, you're closing down the options with regards to the PIA, a Section 115A appeal at that rate. So when someone comes to us, we get them paying what they can afford as early as they can to demonstrate a payment history, to make sure that it's that you can demonstrate what arrangement you're putting in place is going to be sustainable and affordable. And like I said, I think what I was emphasizing there is, when somebody comes to a PIP, the creditors have more solutions available than they just have through their arrear support units, and that's always worth bearing in mind. I think I'm being told to shut up. Sorry, Damien, I've talked too much perhaps, but I'm happy to take questions. Are we leaving those to the end, Damien? Is that?
I think we'll leave those to the end. Yeah, if we could get through the presentations, and then we can take all the questions at the end if that works for you guys.
Yeah.
Okay. Sorry, I'll keep quiet now. Thanks, guys.
Thanks, Ronan. I think next up we're going to pass you over to Gary. Gary, is that okay?
Yeah, that's fine. Thanks. Share screen. Okay. Hi everyone. Thanks for attending this afternoon. I'm going to speak today about SCARP. It's been in the news a bit recently. If we have any League of Ireland fans attending this afternoon. So so a SCARP, what is SCARP? So effectively, essentially, it's a small companies administrative rescue process. It's a streamlined corporate rescue mechanism that was introduced under the Companies Act in 2021. And the goal of SCARP is to provide an efficient, cost-effective process for small and micro companies. The alternative currently, or prior to that, was examinership, which is a court supervised process, and the cost of which were quite prohibitive. Professional fees for an examinership could have ranged from anything from €80,000 to €300,000. So there are a number of key features to the process. The first main one being eligibility. So the company must meet 2 of 3 criteria, and those are less than 50 employees, turnover of less than €115 million, and balance sheet assets of under 7.5 million. Now, it should be noted that 98% of the companies in Ireland would meet those criteria. So it's a simplified process, faster and less costly than examinership, and companies can restructure their debts under the supervision of a process advisor, who's typically a solicitor or an accountant who has specialist insolvency training or experience. The process advisor will assess the company's viability and develop a rescue plan to restructure its debts. So the company can be approved if 60% of creditors in value vote in favour. It can be approved by one class of creditor, and the plan can provide for a write-down of debts across all classes of creditors. It's primarily an administrative process, doesn't necessarily require court involvement. However, the courts can become involved if there are challenges and disputes. And it's typically, it lasts for 70 days. The rescue plan vote has to happen by day 49, and creditors would then have 21 days to object, which is a cooling off period. Sorry. So next slide. So there's a number of steps to the SCARP process. The first one really being the directors of the company will prepare a statement of affairs. And from that, the process advisor will prepare a report. So essentially what you're doing is you're preparing an independent business review. So you're assessing the company and to form an opinion of whether or not the company has a reasonable prospect of survival. If you're able to form that view, then the directors can hold a board meeting to appoint a process advisor. That's deemed then as day 1. So you're into that 70-day process. Now, it may seem long, but once you're actually in that 70-day process, it does go by very, very quickly. So the amount of pre-engagement work that you do, it's quite important. The first key date is day 14, and that's the date where any state creditors who have the ability to opt out would have to do so. Otherwise, they're involved in the process. And we'll come to that in a bit more detail later. The rescue plan would then be drafted and circulated to creditors before day 42. And by day 49, you have to have a meeting of creditors. After that, creditors, as I said, do have the ability to object, and they have 21 days to do so. However, if no objections are received, then the SCARP becomes legally binding. In numbers, so it was really first introduced in 2022. So to date, there's been 76 SCARPs approved in Ireland. The numbers are quite low in comparison to the more traditional insolvency processes. So it has taken a bit of time for there to be an uptake. Now, I would say that for any companies that have entered into the process, roughly around 80% of the SCARPs have been approved. So it has had a positive impact for companies that have entered the process. It's difficult to put your finger on why there hasn't been such uptake, but I think it does come down to a bit of a lack of awareness. It still is relatively new. Also, we would have had the revenue warehouse scheme, and the amendments to that were made back in February. So I suppose the goal of any restructuring process, it's to save the business and to safeguard employment. So the estimated figures are that for any companies that have entered the process to date, roughly around 560 jobs have been saved by the companies entering into the process, which is positive. A recent case that we proposed, well, it was an engineering company with husband and wife director shareholders. And the wife who'd sort of carried out the bookkeeping function had died suddenly. And the other director discovered that the liabilities of the company were significantly higher than he was aware of. He was aware the company had been experiencing reducing margins due to rising labour costs and material costs, but the debts were in around €250,000, of which revenue were around 100,000. So at the process advisor stage, we carried out a review and we suggested a number of measures which were implemented, which included a phase increase in prices to customers, surrender of an onerous lease, and employing an experienced full-time bookkeeper. The rescue plan was predicated on payments over a 36-month period, with preferential creditors receiving 55 cents in the euro and unsecured creditors receiving 15 cents. Now, on that, there was a lot of pushback from revenue and a lot of conversations back and forth, but ultimately the rescue plan was approved and with 10 jobs saved, and the company is now trading successfully. So it shows the importance of the excludable creditors and early engagement with revenue. So certain state creditors have the ability to opt out of the process at a very early stage, which includes the revenue and the Department of Social Protection. Now, they have to demonstrate that there are sufficient ground for opting out, and the kind of things you typically will see is failure to comply with company law in relation to taxation matters, and if there's an ongoing revenue audit intervention, or if there's an appeal ongoing. But in our experience, no, revenue engagement has been positive, and I think these numbers support that. They're generally determined to opt into these processes. From data up to October 23, of the 48 SCARPs proposed, there 45 had revenue debt, and revenue had only opted out of 7. And of the 38 that revenue had participated in, they had approved 28 and had only voted against two rescue plans. So that data would support that revenue are engaging in the process. So I suppose the main takeaways is for a strategy to success and what we have found. So it's that initial assessment stage, affordability and viability. You know, is it a viable company, and is there a realistic prospect of success? Early engagement with excludable creditors, particularly revenue, is essential. And what we would typically do that even before being appointed as a process advisor. And there is a specialist team in Sarsfield House in Limerick that deals with SCARPs. So yeah, we would typically reach out to them at a very early stage. They canvass their views. It's essential that the company's tax affairs are up to date. And what I mean is that there's no outstanding returns or anything like that at the point where you're going to appoint a process advisor, because that would obviously lead the revenue to opt out. A lot of the work needs to be done pre-appointment. We've found that even as far as a rescue plan, that you need to have the bones of a rescue plan formulated before starting the process, because the 70 days does go by very, very quickly. So as the saying goes, fail to prepare, prepare to fail. And then there needs to be a good exit strategy from SCIRP. Though it's essential that there's a realistic business plan in place that can be implemented after exit, and that the company has the required investment in place, because the process may impact its ability to obtain credit. So yeah, so in summary, yeah, look, whilst the process has been underutilized, it is a vital lifeline for small and micro companies, and it's really watch this space how things develop over the next few years. Okay, and maybe hand you over to Keith.
Thanks, Gary.
Thank you very much, Gary. Share the screen. Bear with me. Sorry, that doesn't seem to be working. Sorry, my fault. It's not sharing.
Damien, there's nothing on the settings that you're aware of?
Oh, sorry, I didn't really help there. Keith, I have your slides. Do you want me to share them? And you can
I'll try this one more time, and then otherwise, yes. Yeah, please do, if they don't mind.
Are you seeing that? Yeah.
Yep, that's perfect. Thank you. And you might go down to number 4, September 2024. So I suppose my overview in terms of where personal insolvency sits at, carrying on from what Ronan spoke to us about, is more what can you expect to see and what can you achieve in the court process. So Ronan brought us through a history of the introduction, I suppose, of personal insolvency and how it developed. And the main thrust of the development was the introduction of the 2015 amendment, which meant that you could go to court to get the court to override a creditor veto. The process initially was quite slow. It was a complete unknown for the judges. There was about 6 or 8 specialist insolvency judges appointed. Most of them were former county registrars that took up formal seats as circuit court insolvency judges and sat kind of once a month in the various circuits between Castlebar, Kilkenny, Tullamore, Monaghan to cover the different jurisdictions. It was slow. Pretty much every case got appealed to the High Court because there was no precedent, there was no guidelines on what was fair, what was equitable, and what could be achieved. Whereas by now, September 2024, all bar one of the initial judges have retired. There's one judge left, Judge Mary O'Malley Costello, who sits in Trim. She was a full circuit court judge at the time and is still a full circuit court judge, but sits kind of once every 2 months to deal with personal insolvency, or sits every 2 months to deal with contested personal insolvency matters. Other circuit court judges have taken up the mantle. So now there are, in effect, more judges because it's no longer just the specialists. You have the ordinary circuit court judges. You have more court sittings. So take Dublin, there's probably a sitting every 2 weeks. Trim, plenty of sittings. Tullamore, Monaghan, anywhere in the country, protective certificate within 2 weeks to 3 weeks on a bad month. Whereas if there was good reason for a quicker protective certificate, so if you were contacting the Cambridge Duffy and there was a repossession case next Tuesday, or the sheriff was coming on Monday, there is a procedure that you can apply to the circuit court on an emergency or urgent basis to get a protective certificate. So my summary of where personal insolvency is very much, there are more judges, there's more sittings, there's more hearings, and there's more clarity. There's more clarity because there are less creditors. There's been a huge consolidation of loans, AIB, Promontoria, Ulster Bank. All of those have kind of consolidated to a main creditor in Pepper, Mars, Start Mortgages, and some everyday debt. I think Ronan will probably confirm this, but you also kind of have, because of the consolidation, you have more clarity on what they're going to do, but potentially you have less engagement. So you have creditors that are overburdened with taking on huge loan books, where personal insolvency comes in with a defined toolbox, I think was the phrase that Ronan used, of statutory solutions from Section 102 of the Act, where the PIP can implement anything from a term extension, changing the interest rate, fixing the interest rate, taking someone, for example, off a tracker and putting them on a fixed rate, changing the balance. So I could come in with a 500,000 euro debt and walk out of the PIP's office with a 300,000 euro debt. So the PIP has the toolbox rather than the arrears support unit in AIB or Bank of Ireland. And it's the PIP that puts the proposal forward. That, I suppose, if we can skip 2 slides on to current objections, whilst the PIP has the tools to implement solutions, you have practical problems that are arising case to case. Ronan said age challenged. Age is one of the biggest current objections. You have everything from creditors saying that certain borrowers can't work beyond 65, and then other creditors, I think Ronan had an example with Mars Capital, where creditors will happily extend a loan to age 95. So you have this divergence between what creditors offer, and you go back to the toolbox of the PIP. The PIP doesn't distinguish between AIB and Promontoria or Pepper. The PIP has the same tools and can implement the same solution for every creditor. Certain creditors will say yes, certain creditors will say no. And if you're unlucky to have a creditor that says no to a term extension, we'll say even something modest, age 72 or 75, then the PIP has the ability to go to court to force that solution on the creditor. So current objections, age, a lot of people fell into difficulty 2008, 2010. They've been dealing with this for 10 years now. They're 10 years older, they're 10 years closer to retirement. And ultimately, what has happened in the last couple of years, property prices have gone up and interest rates have gone up. So they now have less time to pay with higher arrears, higher interest rates, and on a practical level, less scope for a write-down of the debt because the price of the property has gone up. So current issues are addressed by, Ronan touched on it, lifetime PIAs. So an ability to extend the loan, often on an interest-only basis, so that borrowers can live out the rest of their lives to stay in a house, guarantee somewhere to live, and then deal with the debt from their estate. So you can read about a PIA that extended a mortgage to age 105. It's not that a borrower is being expected to live to 105. It's a solution that pretty much, bar exceptional circumstances, guarantees them a house for the rest of their life with an affordable payment. So it could be interest only, it could be a fixed payment of 200 or 300 euro per month, and a creditor saying, we're actually happy to just get interest for the next 10, 15, 20 years, and then we'll take the capital sum from the asset at the end. Certain borrowers are happy with that. Certain people are happy with that because they're currently putting kids through college, or there's children that are new into the workforce and they're going to have capacity to buy out that debt in the future, or there's an inheritance coming. So they're happy to say, let's pay interest only for 5 or 10 years, and we're going to get money to clear that in the future. So it's a box of tools existing under a piece of legislation that allows a solution out of pretty much any debt. The case law to back that up, Damien, if we might just jump on to the next slide, ranges, and to be fair to McCambridge Duffy, a lot of these are McCambridge Duffy cases. People and solicitors that are familiar with family law often ask, well, what if the issue has arisen because it's a separation? Can one borrower, my client is the husband or the wife, the other party has left the property, isn't paying, isn't contributing, well, should they're not eligible for personal insolvency because only one's engaging and you need both of them to sign a restructure and the bank won't deal with us? Personal insolvency doesn't operate on that basis. So Judge Baker, when she was sitting in the High Court before she was elevated up to the Supreme Court and recently retired, but she gave a decision, a case called Re JD, which expressly says that personal insolvency operates as an individual insolvency arrangement. It doesn't require co-borrower consent, nor does it require co-borrower engagement. So I can go in, even though I might have a wife on the mortgage debt and am not paying or not engaging, and let's say I'm not even receiving maintenance from them, I can restructure the debt, I can keep the family home, and I can move on safe in the knowledge that I'm keeping the property. So I can see a couple of solicitors that are logged in. There's huge scope to work with a PIP in family law litigation. Having a PIP on your team, as it were, to sort the debt whilst you sort the family law element of the case is an invaluable tool in any family law solicitor's practice. Re Callahan is a decision where creditors back in, I suppose, 2016 or so, tried to push counter proposals, tried to push solutions on PIPs. And Re Callahan sets out that there, again, it was Judge Baker decision, there's a deference to be given to a personal insolvency practitioner in formulating an arrangement because the PIP is seen to be the independent expert. They can do the maths. They're not the bank that's trying to squeeze every last cent, and they're also not the borrower who wants to get every last euro written off. So Callahan says that the PIP is the expert. The PIP's proposal gets deference by the court. And Callahan, probably more of a 2016 issue than a 2024 issue, said that a bank that was refusing to write down debt, it was KBC at the time, KBC wanted to park debt and say, well, we'll collect it from your estate in the future. The court said, if you can't show current affordability to pay the debt, there was no point kicking the can down the road and waiting for it to be paid from your estate. So if it's the case that your house is still in negative equity and you can only afford the value of the house, you can get the debt written down to the value of the house and have that proposal approved by the court. Ronan mentioned as well that there's issues with borrowers that come in and having not paid anything in years, having gotten advice down the pub to say, well, sure, don't pay the bank, and eventually they'll blink first and they'll contact you and offer you a deal. We've all come across clients that have got that advice and are now in the midst of repossession proceedings, or an order for possession has been granted against them. Featherston is a decision of the High Court, and Judge MacDonald, when he was dealing with the personal insolvency list, I suppose articulating how the High Court will look at payment history in an appeal, a 115 appeal situation. And there's no firm answer as to what kind of payment history is too bad to get an approval, but the general summary of the law is you can still get a PIA approved even if you haven't paid in years. If you haven't paid in years, you need to explain why you haven't paid in years. If you didn't pay because you couldn't pay, you were on job seekers allowance and simply didn't have any money to pay, that's a perfectly adequate reason. And the court will therefore look beyond that and look at the fundamentals of the arrangement. And Featherston also said, it's the point that Ronan made, if you start paying when you meet the PIP, You got the bad advice. You meet your solicitor, your accountant, you meet MABs, you meet the PIP, and they say, you need to start paying. You should be paying about €400 or €500 per month. And you start from the day that you meet the PIP. That's going to build up a track record of being able to pay. And from the decision in Re Featherston, that is a new approach and good faith kind of obligation being met by the debtor that will be acknowledged by the courts. So what I'm really trying to say is, don't give the advice to your client that, oh, well, you haven't paid in years, you're not eligible for personal insolvency. You are eligible, but you're going to have to start fixing the bad payment conduct and the history as soon as you engage in the process. And you can't have it both ways. You can't go down the PIP route and still decide not to pay, even if you're asking the court to force a deal on the bank. A couple of other decisions I'll very briefly touch on. Hurley and Phelan, the court will allow people to prove that they are able to live on a very low sum every month and make payments. So under the personal insolvency regime, you're entitled to keep a certain amount of money every month, what's called your reasonable living expenses, to live on. Some people will decide, I'd rather put an extra €100 towards paying the mortgage than going out on a Friday night. The banks actually argued, no, you're not entitled to live below the guidelines. You have to live on the guideline. And if you're not living on the guideline, it's proof that you can't afford the restructure. The court said, no, that's nonsense. You're entitled to cut out. Social inclusion is the heading under the living expenses. It's going to the pub for a pint on a Friday or something like that. You're entitled to cut that out and put it towards your mortgage and prove that you want to keep the property. So strictly speaking, there's nobody with too low of an income. That's probably a stretch from my part. There's nobody that should be cut out from personal insolvency just because there's a view taken that they don't have enough income. That's a PIP consideration. Don't make that consideration without going to a PIP, because you can live beneath reasonable living expenses. Mortgage to rent could be a solution. Parkin is the opposite of that. Parkin was a lady who had a surplus every month. She had more than the reasonable living expenses, and the creditor argued that she could afford to pay more and therefore wasn't entitled to the write down that the PIP was proposing. The High Court said, and these are hard to explain, the two decisions one after the other. The High Court said, you're not expected to live on reasonable living expenses for the rest of your life. You're entitled to a buffer. So there's also the consideration that some people here will have clients that come in and they're working low-income jobs and they're never going to have much above reasonable living expenses, and therefore this isn't relevant. But then you're going to have people coming from a 100 grand a year salary, and they're saying, I don't want to be insolvent. I don't want to live on personal insolvency levels forever. I'm not going down that road. There's a reparking, the High Court decision says you only have to live on the insolvency guidelines for the duration of the arrangement, and you're entitled to go back to a reasonable to a normal standard of living afterwards. And the logic that the High Court applied was, there's going to be contingencies. You're going to need a buffer to replace a washing machine. The roof's going to leak. You're going to need a surplus after the arrangement to live, to change the car, to do normal things. So a bank can't force you to live on minimum living expenses for the rest of your life. Two decisions, the final two on this slide. The current law is that you can't force a term extension to age 200 on a bank, because there's no reasonable prospect that somebody will live to 200. Now, McCambridge Duffy and have adopted, it's called the lifetime tenure clauses. So the example given about extending on interest only to age 90 for somebody, technically how that is done is you extend to age 82, so ordinary CSO life expectancy levels with a roll-on clause. So you extend for life expectancy, and then the terms and conditions continue year on year, like a lifetime loan or refinance. So technically you can't force a restructure to age 200, but there's a way around that by introducing a term and condition into the arrangement. If the bank wants to offer you a restructure to age 200, that can be done. And that's a decision called Kerwin. So not that that makes no sense, but the court has taken the view that if the creditor wants to offer something mental, they can do it if they want, and the court isn't going to stand in the way of it. In terms of the next slide, Damien, I'll be quick on these. People often ask the question, but my client isn't eligible for personal insolvency because they're not insolvent. And you'll scratch that question a little bit deeper, and you'll ask, well, why do you think they're not insolvent? Well, because they've equity in their house, or the farmer is the usual example, because they've a plot of land in Meath and it's worth €1 million. And then you ask, well, why are you here? Oh, because there's a receiver appointed and it's for sale in bid X1 next week, or there's repossession proceedings. So the test for insolvency in a personal insolvency context is cash flow. It's not balance sheet. It doesn't, I won't say it absolutely doesn't matter, but it pretty much doesn't matter if there's equity in the house or there's more value in the land than the debt. It's cash flow. And if somebody is in arrears with payments, if they're in arrears with payments, if there's a receiver appointed, if there's been debt demands from a residual debt from a buy-to-let that was sold years ago, they're all classic examples of cash flow insolvency, an inability to meet your debt when it fell due. So that's a monthly payment that you didn't meet. Another relevant case, I know there's a couple of solicitors logged in, huge amount of lay litigant attraction to arguments at the minute that, oh, my loan wasn't sold properly, that creditor isn't actually the owner of the debt, my loan's been securitized and I don't owe the money to Pepper or whoever. Most of that doesn't save you when the sheriff is coming next week and you don't have time or an ability to go and make those points. But people still don't want to go into personal insolvency because they feel like they're accepting the debt. Is a High Court and a Court of Appeal decision where a borrower didn't accept that a creditor, it was promontory in that case, had the first charge on their property. They said, I dispute them having a first charge, and there's an ability for a PIP. So if you have a difficult client or potentially a correct client that has an issue with the debt or says that the arrears have been incorrectly calculated, just because you go to a PIP doesn't mean that you have to give up all of those issues. The PIP in Langan referred the matter to court and said the debt isn't accepted. So the PIP asked Promontoria to prove their debt, prove that you have the first charge, prove the quantum, prove the security, and referred the issue to the High Court. Promontoria couldn't prove their debt, and the High Court decided, yes, you haven't proven your debt. We're in effect removing your claimed first legal charge and moving somebody else into the first legal charge position. So just a useful consideration for heavily disputed debt cases. By going to the PIP, you're not giving up all of your arguments and you're not giving up all the fight that you had up to that point. Two decisions, and I'll deal with these in one go. They're the only two kind of written decisions from Judge Owens, who's the new High Court insolvency judge, dealing with affordability and sustainability. Judge Owens takes the view that if you have been proving that you can afford to pay something, he's going to give, and this is from the McCarthy decision, he's going to give borrowers the bounce of the ball or the benefit of trying a PIA. There wasn't a real reluctance, back to the Featherston and the payment history case, to speculate or take a punt on borrowers getting an opportunity, because it was such an intrusion on creditor rights. You were forcing a creditor to take a right down their constitutional property rights. The more recent written decisions certainly are more progressive towards, I will give the debtor benefit of the doubt. I will let them try make the payments, and if they fail, it's on their own head. Usually quite good if you go to a good PIP, and the good PIP has properly stress tested the arrangement, has included a good interest rate, perhaps fixed it so that there's not going to be wild variations in what the payment is, then that new High Court approach is certainly of benefit to clients. One thing that had come up in questions was, when is it too late ultimately to go to a PIP? And I know there's a lot of solicitors that other advisors are on. The only point that it's too late to go to a PIP is after the house has been repossessed. So there's one decision, and it's a circuit court decision. It hasn't been appealed or contested in the High Court yet. A decision from Judge Connolly, Monaghan Circuit Court judge, where he said that if you have had your house repossessed and broken back in, so you're technically back in the property, but not legally, then it's too late for personal insolvency. You've lost your eligibility because you've lost your legal or beneficial interest in the property because of the taking of possession by the sheriff. So again, if you're thinking of referring a client to a practitioner, to a PIP, don't leave it too late. Ronan's slides were right. The earlier you go, the more options there are, the more time the PIP has to consolidate their financial affairs, get the tax returns up to date, get payment history fixed so that you can build a payment profile. But there's pretty much never a point that's too late until actually the house is gone. So other than that, I'm very conscious of the time. It's just 2:05. So the only thing I'm going to finish on, the one case that's of most interest to a lot of borrowers is interest rates. I know they've gone down slightly in the last couple of weeks, but there's a huge scope. A decision, again, from Judge Baker called Re Hayes, gives, I won't say unfettered license, but pretty much to PIPs to fix interest rates, and to fix interest rates for as long as the PIP wants for the entire term of the loan. And the one good thing about loan sales is that and as many of you are aware, in insolvency, the general concept is that an arrangement would be the same as what Gary spoke about in SCARP. An arrangement should be approved as long as it's not unfairly prejudicial. For an interest rate to be unfairly prejudicial, a creditor will have to prove that the rate in effect is loss-making for them. So if you fix, in Ronan's example at the start, a rate was fixed at 0.5%. I couldn't get that rate on the market. You couldn't get that rate on the market. How did this borrower get that rate? Because they're in arrears for years and they're going through personal insolvency. And actually the answer is as simple as, in court, when you're having to prove your case, an investment fund is not going to be able to prove that a 0.5% interest rate is loss-making. They won't disclose what their cost of funds is. They won't disclose what they paid for the loan. So it's reverse engineering the argument to actually suit the case. You're never going to go into a repossession case and go, I don't want my house repossessed because sure didn't Pepper buy that for 20 cents. It's not relevant. It's not the test. It's not any matter that will ever come before a circuit court in a possession matter. But in personal insolvency, where the creditor is arguing that 0.5% is unfair, Ronan's answer to that is always going to be, okay, we will assess that, but show us why it's unfair. They won't. The judge will ask the same question and they won't come up to proof. So the strongest suit, my view, for personal insolvency, especially for older and age-challenged borrowers, you might be 60, you see retirement at 68 or 70, you know what your pension is going to be within a certain degree. You can't take the chance for the next 20 years of interest rates going up and down and getting into trouble again. So the beauty of personal insolvency is you can guarantee a fixed payment every month. And with the investment funds that now control the loans, you have a decent chance, everything else being correct, of getting that arrangement approved and forced on the creditor. So I was going to touch on SCARP, but I think Gary's done a fine job of dealing with that. The one recent example there last week, which really shows the power of SCARP for many of the solicitors involved. You have difficult landlords, you have creditors that will object to SCARP just as much as they object to personal insolvency. And one tool that I've seen Gary that used in the last couple of weeks is the ability to modify a SCARP arrangement, which doesn't exist in personal insolvency. So personal insolvency is, this is the proposal, accept it or don't, and the court has to approve it or not. In SCARP, which is a hugely beneficial tool, is a creditor can object to an arrangement, and then Gary, as the process advisor, can actually modify the scheme after the vote and have the court approve a modified scheme to deal with an objection. So for any of the advisors and solicitors logged in, hugely progressive piece of legislation that can be used to sort out hundreds of small companies before jumping into liquidation. It's certainly worth a try. And as practitioners become more and more experienced with it, like, I don't know, between Ronan and Gary, SCARP and the Companies Act introduction of SCARP is pretty much a copy and paste from the personal insolvency legislation. If you can be a PIP, you can do a SCARP. It's just changed the name from debtor to company, which makes sense because of the recent amendments. But it's certainly something that can be used. So unless there's any questions, that's my presentation.
All right. I did notice there that you had to clean up a lot of my presentation by saying there's a lot on Ronan said this and Ronan said that, and very little on Gary. So I think obviously Gary's gonna sort of not let me forget that. Just Damien, is there any questions?
Yeah, we had a couple of questions we received in advance of the webinar too. There was a question around repossession, which I think you sort of answered there, Keith, with respect to when proceedings are ongoing, advanced stage for the house being repossessed. So you were sort of saying, Keith, that as long as the debtors are still in the property, even if a repossession order is granted, there's the possibility to do something through a PAA there.
Yeah, one of I didn't know you were going to ask that exact question, but one of the more famous, I suppose, or two of the more famous McCambridge Duffy cases, the Frank McNamara case and the Ronan Ryan case. Both of those cases, possession orders had actually been granted. One of them on consent. The borrower had agreed to leave the property. And both of those cases ultimately ended up with successful arrangements, people keeping their properties. So it's not too late until you're actually out of the house. So possession order can be granted and you can still go to the public.
Yeah, perfect. And Ronan, maybe you could help us. There's a question regarding RLE's reasonable expenses. Are they set in stone or is there flexibility around those?
No, there is a good deal of flexibility. Actually, just when we were talking about the history of the personal insolvency back in the very early days, I do remember one of my colleagues walking into my office with the legislation in one hand, which he'd flicked to the RLE's bit, and he hands me it, and he hands me the phone, and he said, "It's Joe Duffy. You're on RT." Like I said, I'm like, so he's no longer with us, and it wasn't related to that incident, but it was like probably not a good idea on a Friday afternoon to sort of get yourself sort of put onto Joe Duffy Live. But what I actually said, what I do recall, that was that the RLEs were not supposed to be a beans and toast diet. And what it is supposed to be a reasonable standard of living. As Keith alluded to, it does allow for social inclusion, which can be actually going and having a few pints. They have evolved over that period. Quite often we've sort of found that they can be quite tight in one area of the country, and maybe slightly looser in others. So Dublin, cases, it tends to be that they can be quite tight. But as Keith said, in certain cases the debtor can live on under the RLEs. But in if you're looking at the personal circumstances, so what you're looking at is a base level, which is the RLEs, and then you're building into the household composition and the special circumstances. So the household composition maybe is, how many adults, how many children, how, do they need 2 cars? Do they have 2 cars? Do they need 2 cars? Those types of things. And then the special circumstances may be around perhaps health insurance. Maybe there's pre-existing medical conditions that, it would be, folly for the creditors to try and force them to give up their health insurance. And of course then, college it can be obviously a very big expense, but what you're looking to do for the lifetime of the arrangement is to build up, maybe a sort of snakes and ladders, if you like. So you may be about stepping up the level of expenses, and then as the college finishes, coming back down. So it's there is a very good deal of scope, but I think what you have to do is try and when you're putting forward 2 creditors, explain the circumstances, explain why these additional expenses are needed. I actually remember a case that I did actually in the UK where they had included expenses for horse riding for their children, and I remember thinking, this is nuts, And in actual fact, they said that the debtor's children was a prospect for the Olympics, and I explained that to creditors, and creditors were happy enough to accept it. I would have had the horses in the glue factory, but they were actually. But I did go back and check after I think it was the 2012 Olympics or 2016 maybe Olympics, and that family, they did have an Olympic medalist at the end of it, so it shows you I was wrong, and it shouldn't have been in the glue factory. So there you go.
There's your part, Ronan.
So okay, anything else, Damien? Any other?
Yeah, there's Linda's one final question here. So a PIA section 115A moved to the High Court, Ulster Bank case, no consent to sell mortgage onto Pepper. Any experience with this type of case? That one's for you, Keith.
Yeah, it happens quite regularly. I'm reading the question here. Moved to the High Court. I assume that's on appeal then from the circuit to the High rather than a transfer. It's very rare that they're transferred. And I'm guessing I'm probably in the case. But most of the time, the borrowers don't take an issue with the transfer of the Ulster Bank debt to Pepper in the middle of the PIA process. Now it'll depend case by case, but for the most part, borrowers don't care who owns the debt as long as the PIA gets approved. Like there's no point fighting about the transfer if ultimately you want the deal, you want the debt write-off, and you want the PIA approved. So it depends if the case is going downhill and there's a problem and it's not going to be approved, maybe there's an issue with fighting the transfer. But mainly I've seen consent substitutions where Pepper will be substituted in for Ulster Bank because ultimately the borrower wants the debt sorted and they couldn't care less who holds the debt.
Yeah, I would echo that. It tends to be, and a lot of the banks are so focused on cleaning up their book, and that's as a result of sort of Basel III Capital Directive. It's entirely understandable that they wanted them off their books. And although they have, vulture funds have funds have a bad reputation, perhaps, by and large, we find them more likely to do a sensible deal, particularly if it's already on appeal. They may be open or be more amenable to doing something, as Keith says, out of the PIP's toolbox. The banks tend to be less flexible or a bit more rigid and a bit sort of, computer says no, or, we'll have to run a past credit type thing. Whereas in actual fact, you just need to make it work for the creditor and make it work for the debtor. Anything else?
Guys, no, that's all the questions we have now. So that's great. Thank you very much, and thank you for everyone who has attended today. We hope you found it beneficial and useful. But if there's any further questions, or feel free to reach out to us. We can help you with any questions, or if there's anything you think of afterwards. So as far as from us, thank you very much, and have a good weekend, everybody.
Okay, enjoy your weekend, everybody.
Thanks.
Bye now.